Welcome to The Explainer. Today, we're unpacking exactly how the justice system handles freak accidents and inherently dangerous situations through the lens of strict liability. We're going to look at what actually happens when the absolute worst occurs, even when you've tried your absolute best to prevent it. Okay, let's dive into our roadmap for today. We'll be looking at liability without fault, strict liability for animals, the wild animal case, abnormally dangerous activities, the restatement test cases, and finally, defenses and final thoughts. Section 1, liability without fault. We're going to start by defining exactly what it means to be held liable when you did absolutely nothing wrong. Now, what's really interesting here is that we have to completely throw out our traditional tort concepts. You can just forget about intentional, reckless, or negligent behavior for a minute. We're basically discarding the entire due care assessment. Seriously, it doesn't matter if you acted perfectly reasonably under the circumstances.
So our first black-letter law definition today is strict liability, or liability without fault. The absolutely crucial point here is that even if a defendant exercised maximum due care, they still have to internalize the costs of foreseeable harm caused by their activity. It's an automatic legal responsibility. If your specific activity causes foreseeable harm, you pay for it. End of story.
Moving on to Section 2, strict liability for animals. Let's go ahead and test this concept against the first major branch of strict liability, which categorizes animals into livestock, domestic, and wild. All right, picture this scenario. A woman named Jeannie rescues a puppy, nurses it back to health, and then boom, discovers it's actually a purebred wolf. To protect everyone, she puts up a massive 10-foot fence with "Beware, vicious animal" warning signs. But one day, the sleeping wolf wakes up and bites a teenager, Tom, who just climbed the fence to fetch a foul baseball. So, is Jeannie strictly liable to Tom? Does she have to pay for his injuries? Well, the answer is yes. Even with the utmost care and a totally secure cage, private individuals keeping wild animals face absolute strict liability for injuries resulting from the animal's legally presumed dangerous traits. Now, if this were just a domestic dog, we'd use the known dangerous propensity rule, meaning she'd only be liable if she actually knew the dog had a history of biting. But because a wolf is a wild animal, an animal that literally cannot be truly tamed, its dangerous propensities are legally presumed. Jeannie is strictly liable. No way around it. Section 3, the wild animal case. To see how this actually plays out in a real courtroom, let's examine the rather dramatic 1983 Kansas case of Mills v. Smith. The facts here are pretty terrifying. The defendants owned a 90-pound African lion named Chester. While family was visiting, the grandparents were taking photos, and the distracted mother lost sight of her 21-month-old toddler. The toddler ran up behind the lion, and the lion knocked the kid down and severely bit her head. So, since the lion owners are strictly liable for keeping a wild animal in the first place, the core legal question is this: does the owner's strict liability prevent the jury from blaming the negligent parents? Can the simple negligence of the custodians, the mother and grandparents, who clearly weren't watching the child, be compared to reduce the damages? Here is the black-letter law on this. A possessor of a wild animal is strictly liable for harm resulting from dangerous propensities, subject to comparative fault principles, meaning the jury actually has to compare the strict liability against the negligence of all contributing parties. So the court concluded that causal responsibility had to be apportioned, and it resulted in a fascinating split. 40% fall to the strictly liable owners, 50% to the distracted mother, and 10% to the grandparents. The big takeaway here: strict liability doesn't automatically insulate a plaintiff from their own comparative faults. Section 4, abnormally dangerous activities. Now we're going to pivot from wild animals to our second major branch, inherently hazardous commercial and industrial operations. To figure out exactly what qualifies abnormally dangerous, courts use this brilliantly helpful 6-factor restatement balancing test. They're looking at things like the high degree of risk, the likelihood of great harm, the inability to eliminate the risk with reasonable care, whether it's a matter of common usage, the inappropriateness of the location, and finally, whether its value to the community is outweighed by its danger. It's kind of like a giant puzzle courts have to piece together. Section 5, the restatement test cases. We are going to apply these 6 factors to 2 wild, real-world case briefs to see exactly where courts draw the line. Let's look at the facts of our first test case, Edwards v. Post Transportation from 1991. A simple construction error led to mislabeled chemical tanks at a plant, so a delivery driver unknowingly pumped sulfuric acid into the wrong pipe. The acid mixed with sodium bisulfite residue, causing a violent chemical reaction that released a highly toxic gas cloud, and the plaintiff suffered severe injuries in an adjacent area. So we've got a highly toxic, reactive chemical. The question is, does the delivery of sulfuric acid constitute an abnormally dangerous activity? Does it automatically trigger strict liability? Well, the California court ruled no. And their rationale is fascinating. They stated, where the activity is dangerous only if insufficient care is exercised, ordinary rules of fault are sufficient for allocation of the risk. Basically, expert testimony proved the actual risk could have been completely eliminated through proper handling and care. It failed that crucial factor C of our restatement test. Because the risk arose entirely from a failure of care, those mislabeled pipes, standard negligence principles apply, not strict liability. All right, let's look at the facts of our next case, Toms v. Calvary Assembly of God from 2016. Here, a church hired professionals for a 250-shell fireworks display. It was properly permitted, they used a 300-foot safety radius, totally by the book. But the neighboring dairy cows were startled by the noise, which caused an indoor stampede that sadly killed 4 cows and caused significant property damage. The farmer sued, of course, demanding strict liability. So we have to ask, is the noise emanating from a lawful fireworks display abnormally dangerous to livestock? I mean, firing explosives into the air seems inherently dangerous, right? Well, comparing these two strict liability failures really shows us exactly where the line is drawn. Both plaintiffs lost their strict liability claims, but for completely different reasons. Edwards lost because the severe risk of the sulfuric acid could have been eliminated through the exercise of reasonable care and safety protocols. Toms, on the other hand, lost because lawful, regulated pyrotechnics are a matter of common usage, whose social value simply outweighs the hazard. Fireworks are culturally valuable, so they don't trigger strict liability here. Section 6. Defenses and final thoughts. To wrap up this explainer, we need to look at what happens when strict liability is successfully applied and how defendants can still fight back. If you're a defendant, you actually have some options when it comes to affirmative defenses. Notice how contributory negligence is a red light. It generally won't completely bar a plaintiff's recovery, but look at the yellow and green lights. Defendants can successfully use assumption of the risk, or, as we saw in the Lyon case, comparative negligence, to significantly reduce or even completely eliminate their financial payouts. So I'll leave you with this final provocative thought. When freak accidents occur, how should the law actually balance the community's need for dangerous industries against an innocent neighbor's right to safety? Because strict liability really isn't about punishment. It's about deciding who should bear the heavy cost of progress and the inherent danger in our modern world. Thanks for joining me on this explainer, and I hope this keeps you questioning the baseline of the law.